Good morning, everybody. Welcome to this First Thursday Club on the 6th of April. Today, Nigel is going to talk to us about essential NEC cases. Nigel is the Managing Director of Stradia, a consultancy company. He's an expert on the NEC, delivering all the training for NEC contracts, part of the ICE. And project management courses as well. So Nigel, you can probably introduce yourself far better than I can, so I'll hand over to you.
Thanks, Suzanne, and good morning and welcome everybody to this NEC discussion. So just a little bit more about myself. As Suzanne mentioned, I've been using the NEC contract now for probably in excess of 25 plus years. In different ways, helping clients, get into an NEC contract through the procurement process, selecting options, ensuring then when the contracts are awarded that the teams understand their roles and responsibilities under the contract. So yes, I'm also an advisor to the RICS as well. I'm one of their consultants and advisors and trainers on NEC and other forms of contract. So I'm going to share my experiences with you this morning. We've got an hour, so obviously we've not got too much time. So I've condensed some material down into what I think is some of the important aspects of the NEC and relating that to some case law, which kind of reinforces some of the NEC principles. So what I've done is just kind of put down a few objectives that I think are relevant for this morning. So increasing awareness about some of the essential NEC cases. And I have to say at this point, there are not a huge amount of cases which relate to process and principles in the NEC contract. And I think that's because the contract is well drafted. And I think for those of you who've used the contract, hopefully you find it fairly straightforward, plain English. So the case law is really largely around failed kind of adjudications and things like that, rather than the principles of the NEC. But what I've done is condensed some aspects of the NEC into some case law. So having a look at the implications of that case law on contract administration and considering perhaps what we might do differently in light of the cases that we're going to discuss. So my first thought was actually to have a look. In my experience, I'm also legally trained as well and get involved in construction disputes. What causes disputes under the NEC? What's the background to any disputes that I tend to find in my practice? So these seems to be the causes. I've got a few sort of notes here that I'll just run through with you. So poorly drafted and amended contract seems to be one of the hot topics when things go wrong. Inappropriate transfer of risk, clients trying to change the contract to transfer risk inappropriately to contractors and the rest of the supply chain. Sort of poorly administered tender processes and wrong selection of options. So clients picking the wrong option, not perhaps understanding the implications of the choices that are to be made in an NEC contract. Ending up with conflicting contract documents, inappropriate secondary options. Also, this is one of the primary things we're going to be discussing today, is perhaps project managers' lack of understanding of their responsibilities under the contract and how project managers should administer the contract. And failure to give proper notices is another area. This contract contains some very strict some very strict requirements on notices and timescales. People seem not to follow those, which leads to difficulties. Not using the early warning process correctly, or not using it at all in some instances. So that process, the NEC and drafters of the contract would say is one of the most important processes in the contract, yet perhaps sometimes that's not properly understood. And poor communication and poor communication systems. The contract requires some fairly rigorous protocol on communication, which often isn't followed, leading to difficulties and disputes. Confusion about the differences between options, option A and option C. People do seem to manage to get a little bit confused about when things are paid using defined cost and so on. And and how to calculate a quotation for a compensation event under the different options. Timescales not being followed, as I mentioned earlier, and people who've come from a different background, maybe a JCT background, assuming automatically that the NEC contract has the same provisions in it as other contracts. And in my view, it's quite a different contract than, let's say, a JCT contract, and needs to be administered in a different way. And also, I think people who say leave the contract in the bottom drawer, don't use the contract, we don't need it, we're partnering, we're looking after each other, I think that's a mistake. That causes issues. Failure to assess quotations properly. People like to sort of somehow separate time and money out of a quotation and treat them separately. Well, that's not how this contract works. Again, that's an area for difficulty. Not producing the programme in accordance with clauses 31.2, so not having an accepted programme all times, and unsubstantiated compensation event quotations. So that's just a few things that causes problems, causes dispute in this contract. Most disputes, I have to say, can be settled, through discussion. Hopefully we've got, the right attitude. We are collaborating and cooperating with each other. So disputes or disagreements, problems at least, can be resolved sensibly. But if not, then of course there is recourse to adjudication, and we don't get details of decisions from adjudications. They're private, so we don't necessarily know how adjudicators have found or the decisions they've made. So I think, again, another principle that perhaps, again, it isn't understood is how do we work collaboratively, cooperatively? And let's explore that in a bit of detail. So what I've done then is I've chosen some cases that I think kind of explained some of those things that I've just mentioned, and how perhaps they should have been dealt with and perhaps weren't. So I'm going to pick on two areas. I'm going to pick on contract administration, the role of the project manager, and compensation events for this morning. And I'm going to relate some cases to you which highlight some of the key aspects of these two areas of the contract. So let's talk about the role of the project manager and how the project manager should administer the contract. Now, just a few points about the project manager. The project manager is appointed by the client or employer, depending which version of the NEC you're looking at. So that can either be an internal appointment, either somebody is selected from the client's organisation, or it can be an external appointment, a consultant. So it's the client's choice as to how they or where the choice they make about the project manager. So the project manager then is named in contract data part 1. So once the client has selected the project manager, the details of the project manager goes into the contract. And it's only the project manager who has the power to change the scope. That can't be done by the employer or client. It has to be done by the project manager. And I always say to clients, I think one of the key choices you make, one of the key decisions you make using this contract is make sure you've got a competent project manager, right experience for the project, and fully appreciates and understands the NEC contract. And I strongly advise as well that the project manager is an individual, a person, not an entity. So the project manager has sort of personal duties to perform. If you make it an entity, if you name a company as the project manager, then essentially everybody in that company is the project manager. So that's never going to work properly. So all the advice, all the kind of guidance would be to name an individual. Now, if you need to change that individual, then that can be done by the client, but only the client. So we're going to consider the project manager in the context of the certifier, the role of certifying payments, assessing quotations for compensation events, and so on. So we're going to look at the role of the PM from that point of view. And one of the underlying factors we're going to consider is that the PM has to always act in the best interest of the project. It's a kind of independent role, has to act even-handedly. So whilst the appointment is with the client, the project manager has to act in the best interest of the project and in accordance with the contract. So clause 10.2, 10.1 and 10.2 require the project manager to do as the contract says. So when a project manager makes the decision, then accepting, say, let's say, programs, or accepting quotations, or accepting designs, accepting anything under this contract, the NEC does not transfer responsibility. So the PM can sleep at night knowing that whilst they've accepted those designs or the programme, that responsibility or the liability for that programme or design hasn't transferred to the project manager under clause 14.1. It's essential, I think, and this is a debatable point, but I think the project manager does need to be sufficiently close to the project to understand what is going on, how things are working. The project manager, in my view, is a little bit similar to a managing director of a company. So not only responsible for, sort of process, but also ensuring that everybody understands their roles, that the process and procedure is working correctly. And if it isn't, then the PM needs to fix it. So it's a really key role. I can't overemphasize how important this role is. The project manager also, as I mentioned, has to act in the spirit of mutual trust and cooperation, which kind of emphasizes the need for that independence. So let's have a look at some case law. Now I'm going to start with some case law, which isn't actually NEC case law, but it helps understand the role of the PM when it comes to how the PM should act independently and impartially. So the first case, these cases now go back some time, but they are, if you like, the current position with regard to independence of a certifier. So this case, Sutcliffe and Thackeray, goes back to 1974. We've got a bit of feedback there. Let's just see if I can get rid of that. So the employer and the contractor make their contract on the understanding that in all matters where the architect, or read PM, has to apply his professional skill, he is to act fair in an unbiased manner in applying the terms of the contract. So think about that for a minute or two. And then another case, similar time, similar period, London Borough of Hounslow. Under a building contract, an architect, and you can read PM, has to discharge a large number of functions, both great and small, which call for the exercise of his skilled professional judgment. He must throughout retain his independence in exercising that judgment. It is the position of independence and skill that affords the parties the proper safeguards and not the imposition of rules requiring something in the nature of a hearing. So again, another important case to determine how our project manager should behave and act under the contract. So then from from those cases and others, then two propositions really emerge from the authorities concerning the position of the project manager. So when performing their duties as a certifier, the project manager is required to act in a manner which is independent, impartial, fair and honest, and that is absolutely vital to the management of an NEC contract, absolutely fundamental to it in my view. The project manager must use their professional skills to and their best endeavours to reach the right decision as opposed to a decision which favours the interests of the employer. Another key thing to bear in mind. Now, project managers make mistakes. We all make mistakes. Well, that's okay, but as long as they have, when they've reached their decision, even though it might be the wrong decision, even though they've reached the wrong decision, that must be on an impartial basis. They've got to have decided whatever they've come up with as an impartial, independent certifier. The precise role and duties of the project manager as determined by the terms of the NEC contract under which they are required to act. So that doesn't mean they work in isolation of the employer or the contractor. They obviously will consult. They'll work with the employer, with the contractor, to ensure that the particular issue, the particular problem, the certificate or whatever it is, the project manager has taken proper account of the contract in particular, but has also listened to both the employer and the contractor, and has come up with a decision which represents a fair reflection of what the contract requires. So let's turn to some NEC cases then. Okay, so this one goes back to 2005, Costain and Bechtel. And this one was all about the pressure applied by the employer, by the client, on the project manager. And I think this one really does emphasise the importance of the PM acting even-handedly and impartially. So this goes back to NEC2, Engineering Construction Contract, option C. For those of you who know something about these contracts, this is the target contract where the contractor is paid defined costs for the work. Those costs then are compared to the activity schedule prices, the target, and if there's a saving against that target, when all the defined costs and fee have been accumulated and compared to the target, the activity schedule, if those costs plus fee come in under target, then there's a share of the saving, which is really what this whole contract is about. It's about driving efficiencies, encouraging the parties to work collaboratively together, and hopefully in doing that we'll achieve some efficiency gains which will be shared. So it basically improves the contractor's margin, and the client, the employer, gets the work completed at a lower cost. So that's the fundamental basis of an option C contract. Now, in this particular case, it was an option C. However, the employer was instructing the project manager to disallow certain legitimate costs amounting to 5.8 million. So in other words, the employer was pressuring the project manager to disallow costs. Now, again, some of you will know under this particular contract that we have, well, it used to be called actual cost in NEC 2 days, now called defined cost, and we have disallowed costs. And disallowed costs are costs which will not be paid to the contractor, because under the contract, these costs are identified as part of the administration of the contract. So what they were doing here, what Bechtel were doing was they were administering the contract sort of unfairly due to the pressure applied by the employer, which meant that the contractor was not getting paid, in this case, up to 5.8 million. So, of course, it all went to court. The contractor, Costain, were obviously very aggrieved at this, and the court found that, the project manager had not acted independently and acted unfairly under the contract, and because of that, the contractor was awarded damages for the failings of the project manager. So where does that take us? Well, clearly, what should the project manager have done? Well, the project manager should not have acted in that way. Yes, no, the project manager would listen to the employer, but the PM should not be taking instructions from the employer to reduce those costs. The employer should not be interfering in that process. So we'll come on to what the employer should have done in this case, but not the employer should not have applied that sort of pressure to the project manager. And of course, either way, the project manager is either an employee of the client, of the employer, or is an independent project manager. Either way, the project manager should not have behaved in the way that they did in this particular instance. So this is the case that I really want to draw your attention to, because this is a more recent case. It's about 5-6 years old now. But this one I think is really alarming. I thought that one was quite alarming, but this one is really alarming. So you might have come across this, but this one was probably a bit of a field day for the lawyers, because this one there were six judgments in this particular case, and there were 4 adjudications. And probably this is a good example of how not to behave when you get a dispute, because this must have cost the parties an absolute fortune in terms of legal fees and so on. And yes, okay, it's easy for me to say with hindsight, but perhaps that could have been avoided with a little bit more of an understanding of the contract. So what happened in this particular instance, this is ICI, the employer, MMT, the contractor. Basically, again, this was an NEC, this was an option A contract in this case, and ICI had contracted with MMT to carry out works at one of their paint production facilities. Now, initially the works were in the order of 1.9 million. That was the original total of the prices. However, as the works proceeded, there were numerous instructions given to MMT by the project manager, and the works grew to something around 20 million. So, from 1.9 million to 20 million, a huge increase in the total of the prices. So obviously this did cause some alarm within the client organisation, but nevertheless, these were instructions that were given by the PM and valid instructions under the contract. So this pushed the capital expenditure, the CapEx figure for the project, far beyond what the client parent company, AkzoNobel, intended to pay. They didn't have the budget for it. It had gone well above the amounts that they had allowed in their CapEx, their capital expenditure budgets. So what did they do? Well, just extract from the case. The CapEx was governed by AkzoNobel's approach to MMT. In other words, AkzoNobel had no intention of paying MMT that amount of money. They wanted to try and keep the total of the prices within the contract to within their CapEx budget. So this is where the problems start. So around about the sort of mid-2014, AkzoNobel, it became clear that they had no intention of paying MMT the amount that they were due, the value of the works that they were due under the contract. The project manager was doing what project managers should do. The project manager was, valuing the works, any compensation events properly as through the process in the contract. However, AkzoNobel and ICI were putting a lot of pressure on the PM, who was incidentally an independent PM. He was an external appointment, someone who had been appointed as if you like, a consultant PM under the contract, so not part of the employer's organisation. And what the AkzoNobel were trying to do through legal action was to argue that the amounts that were ascertained or the assessments made by the project manager were too high. So that was a real issue. The project manager, meanwhile, still really doing what the project manager should have done and resisting pressure from the client. However, it appeared that AkzoNobel ICI's approach was really to pay as little as they could to the contractor, and in a sense the view was that they were trying to drive the contractor into receivership, into liquidation. So that was not working for the contractor, not working for the PM. The pressure that the client was applying was just simply ridiculous. So the PM was not doing what the client wanted them to do, and that was to just pay what the client wanted, to pay. So what happened was the client dismissed the project manager, terminated the project manager's contract. So they then appointed someone from their own organisation. The client appointed someone from the parent company's organisation, from ExxonMobil's company, to become the project manager. So as an employee of the client, of the employer, this project manager, the new project manager, was of course doing exactly what he was told. And in the end, I mean, he was described as a stooge by the courts, not actually doing what the PM should do, and simply going along with any instructions he was given, which of course then was clearly not as we've just discussed. The PM was just stepping outside of that independent, impartial, even-handed role. And of course, then it proceeded to court again. There had been previous court actions regarding the value of the previous PM's assessments. However, in this particular action, it was around whether the client or the employer was entitled to do what they did in putting in one of their own people who was just acting as a stooge, to use that term. So anyway, the court found that those actions, the actions of the employer, were in a sense a repudiation, wrongful repudiation of the contract, and the contractor then was going to be awarded damages for that. Also, in the meantime, the client had then raised counterclaims, just as a side issue, for defective work in a desperate attempt to try and manipulate what they paid back down. So they raised counterclaims for something in the order of £5 million, which the court found was actually, or the court more or less dismissed as almost nothing in the end. So as well as that, the client, the employer, counterclaimed against MMT, the contractor's entitlement. They said that the contractor had been overpaid by £10 million. You can imagine this is an absolute field day for lawyers and consultants and everyone else, expert witnesses. This is just not how to behave when you get into this situation. So having determined the question of liability in favour of MMT, the court turned then to quantum. And this was another key issue, and this is something I think that's important. If you've got any project managers listening to this, this is important, because one of the crucial issues then for the court was we decided liability, but then the court turned to quantum and had to determine what to do in this instance in terms of quantum. So the independent project manager had obviously evaluated the works, and the court had to decide whether those valuations, and indeed the valuations of the in-house project manager, could be challenged. Now, it was accepted by the court that, of course, these things could be challenged, even though the project manager was acting as the project manager should, in an even-handed way. Then could the court challenge that? Well, it was decided, of course, that the court could challenge, and an adjudicator could challenge those amounts. So I said earlier that the project managers, if they're doing their job properly, should be acting impartially, even-handedly. But even so, project managers could still make mistakes, even though they're acting in that capacity. So it is right, I think, that the courts can challenge, or that the employer could, or the contractor could indeed challenge the assessments made by a PM, absolutely. And that's what the court decided. But having heard expert witnesses on the amounts that had been certified, then the courts were satisfied that virtually everything that had been certified by the independent PM was correct. And the courts also commented to say that, of course, it's very powerful evidence that if the PM is acting truly independently, then it's going to be very difficult to challenge those amounts, because the PM is empowered to make a judgment. And of course, if they are truly acting even-handedly, then it's going to be difficult to challenge those independent assessments. So nevertheless, the amount that the court awarded to the contractor was 9.7 million. So not a lot less than what MMT were looking for. So I found that case amazing. I found, how can you get into such a mess, and how would an employer, how would a client act in that way? Well, there you are, it actually happened. So some key conclusions then from that. Courts, adjudicators can challenge the amount certified by the project manager. That I think is absolutely right. And there's nothing in NEC 3 that makes the project manager's assessment final. They've made some amendments in NEC 4, but NEC 3, that was the case. The independent project manager assessment is clearly a powerful evidential, carries a powerful evidential weight in the event of a challenge. But however, if the PM has not acted impartially and even-handedly, then of course, then that leaves challenge very much open. So yes, the amounts certified by the PM are open to challenge, but only under very sort of limited legal evidential circumstances. So where a claim for the project manager assessment is to be re-evaluated, then the task will be very much impossible without cogent evidence that the parties did not intend the PM's assessment to be final. And of course, when we're talking about compensation event quotations, you probably will know that once the PM has made an assessment, that quotation cannot be opened up by the PM or by the contractor. It is final and binding, and only an adjudicator can open it up, or if you've used the assessment, the assumption process, but otherwise they're final and binding. So let's think about this, and if you have any questions, just put your hand up on the screen and I'll take any questions. But this raises some interesting points, I think. So does it make a difference, do you think, if the project manager is an employee of the client? Does it make any difference? Should we do anything differently? If you are an employee, do you have to behave in a different way? Well, I think the answer to that is no, you absolutely can't. You might well be an independent, you might well be an employee of the client, but you still have that impartial role, which makes it difficult because you might be reporting to your boss, let's say, but nevertheless, as an employee, you've still got to act impartially in the role of the project manager. So what we recommend is that if you are an in-house employee and you become the project manager, then having some terms of reference that allow you to act in the capacity of the PM, I think is good practice. So in other words, you might have financial limits as an employee, and so on and so on. You under the contract, you're empowered to issue instructions. I had a client last week tell me that their project managers were not empowered to issue instructions, and I'm thinking, well, how can you possibly be a PM if you're not empowered to issue instructions? So perhaps there needs to be what we call terms of reference given to the PM to allow the PM to act, as the PM under the contract, if you are an in-house employee. So what happens if the client does disagree with the project manager's assessment, which clients can do, of course, if the PM has acted even-handedly and fairly and come up with a decision and issued a certificate, then what can the client do about it? Well, the client should not be behaving like the ICI case just mentioned. What the client should do, of course, is issue a pay less notice. And of course, then the PM is protected because the PM has made their decision. If the client disagrees with it, then the client can go and issue a pay less notice. And I'll come on to that in a second. So what happens if, what happens if the client disagrees? Well, then it would be a pay less notice. So very quickly, I'm sure you're all familiar with the NEC process. So what would happen is the PM would issue their certificate in accordance with the contract, and then of course, if the client disagreed with that, if the employer disagrees with it, then they can issue a pay less notice, provided that is done no less than 7 days before the final date for payment. So that's how it should be done. And of course, then the contractor may dispute the pay less notice, but it's not putting the PM under any pressure because the PM has acted as they should have done under the contract. So it should not have been done as ICI behaved. Okay, so turning to some other aspects of the NEC contract, notices and compensation events. So I'm going to talk to you about a case some of you may have come across, Northern Ireland Housing Executive versus Healthy Buildings, which is an interesting case. And again, went through adjudication, went through the High Court and went to the Court of Appeal. So it was a case that took a bit of time to eventually decide. So this involved the professional services contract, the PSC NEC 3. Now, again, the terms and conditions of this contract are almost identical to the ECC, but we're talking about professional services here. So this particular dispute started life as an adjudication. It involved testing properties. So the Northern Ireland Housing Executive had thousands of properties, has thousands of properties. What they wanted was their properties testing for asbestos. So what they did was they wanted to engage a contractor to do that. So they went out to tender. And in their tender, they said that the contractor, the consultant in this case, was more or less free to decide how they went about the tests, the method statements that they wanted to use. So basically, the end result would be an understanding of which properties were subject to asbestos. So basically, in the scope, the contractor was left to decide their own method of working, which was fine, no problem with that. So that all ended up in a dispute, which I'll explain to you in a minute. So the dispute started as an adjudication and ended up going to the High Court and then to the Court of Appeal. So what happened then was that the employer under the contract decided that, well, I'll just turn the clock back slightly. So the contractor had decided how they were going to carry out the works, how they were going to carry out the testing, and the method they were going to use, it revolved around testing 1 or 2 rooms in each of the properties, not testing every room in all the properties. And that's how they won the tender on that basis. So later, sometime after the contract was awarded, but not too much time, the employer issued an instruction to the consultant, to the contractor, stating that they wanted every room in every property testing. So they changed the way in which the contractor was allowed to carry out the works. They put restrictions on it. They changed the method of working. So of course, this would become a compensation event. So wherever the client changes the scope, then that becomes a compensation event. And this was discussed, this kind of instruction was discussed at a meeting, and it was recorded in that meeting that this is what the client wanted to do. So you could say there's a bit of a breakdown there in the fact that it wasn't given as a sort of formal written instruction, but nevertheless, it was not disputed between the parties that the instruction had been given to change the method of working. And it was accepted that this became a compensation event under the contract, because wherever there's a change in the scope, that becomes a compensation event, particularly where the instruction is given by the client. So that's fine, and that was kind of understood. So the contractor then, some months later, notified the compensation event. It hadn't been notified at the meeting, but later the contractor notified the compensation event. But let's say it was somewhere around the February of this particular year, the instruction was given in the meeting. But in the May of that year, that was when the contractor notified the compensation event. So whilst it was accepted in principle, it was a compensation event, the notification for the compensation event wasn't given by the client. It was given by the contractor several weeks, many weeks later. And this is part of the problem. So the dispute then revolved around, firstly, was it a valid notification, because the client argued that it was outside the 8-week period in the contract. So you might know that in NEC and particular PSC and ECC, the contractor consultant has to notify within 8 weeks. And part of the reason that the employer decided it was not a valid compensation event was because it was out of time. And secondly, the employer also argued that even though they'd already said it was out of time, they also argued that it had no effect on cost or time. So in other words, even though they argued it was outside the 8 weeks, they also argued that even if it was an acceptable notification, that it wouldn't matter anyway, because the change in method of working had no effect on cost or time. So of course that upset the contractor. They felt that clearly doing this, changing their method of working did take longer and did cost more. So they went to adjudication. And so this is the first sort of port of call. They went to adjudication. And of course, well, you can probably guess the outcome. The adjudicator found in favour of the consultant, the contractor, because the adjudicator said, well, in the first instance, the instruction was given by the employer. So, the obligation then, because the instruction was given by the employer, is that the employer should notify. And that was the obligation. So therefore, the 8 weeks did not apply. And secondly, the adjudicator found it unlikely that because the contractor was doing more work and taking longer, that was not going to cost any more. So the adjudicator found in favour of the contractor. So the employer's argument was, well, it seemed like the contractor was sort of to use the term mentioned in the case, keeping the compensation event in their back pocket and only going to raise it when they felt they wanted to, and therefore it was outside the 8 weeks. So just turning to the ECC for a minute or two. So just to kind of make you aware where all this is coming from, this 8 weeks. So if we're talking about the engineering construction contract, then if you're looking at clause 61.3, that's where the 8 weeks comes from. But it doesn't apply if it was the project manager, or in the case of the PSC, the employer, who should have notified the compensation event. So that's why the adjudicator found in favour of the contractor in that instance, because the instruction had been given by effectively the PM. And also, if you look at the reasons why the PM or employer may decide that the compensation event is not a compensation event, is because it hadn't been notified within the timescales we just discussed, and also had no effect on cost or time. And I'm just showing you the clauses in the ECC contract. So that's what the employer was relying on. But the adjudicator found, well, that wasn't the case. So not put off by that, not put off by the fact that the adjudicator had found or made a decision against the employer, the employer decided to take that to court, to take it to the High Court, which is what they did. So again, now from adjudication, which is not, it's quite expensive, you're moving into the High Court, which is now getting very expensive. So we've now got these same arguments being run in the High Court. We've now got solicitors on both sides. We've got expert witnesses on both sides, and we've got counsel on both sides. So it's getting really expensive. And they run the same arguments again. The same argument was run in the High Court, and guess what? Again, the employer lost. The courts found in favour of the contractor, the consultant, and not put off by that, they're a determined bunch, this housing executive. They decided to take it to the Court of Appeal in Ireland, which is what they did. And again, they ran the same arguments, but this time we've now got sort of solicitors on both sides. We've got counsel, we've got QCs, or KCs as they're now known, on both sides. So it's getting eye-wateringly expensive. And again, they lose the case. The court found against the employer. So how much time was spent on that? How much money was spent on that? Well, who knows? But this was all a matter of principle. There was no quantum involved in this particular issue here. It was about matters of principle. And they'd spent an eye-wateringly amount of money just to find out really what the contract said. And okay, there's obviously differences of opinion. There always will be differences of opinion. But I think reading the contract, it seems to me to be plain English and so on. I do think, however, the employer may genuinely have felt that there was no cost or time implication in changing the method of working. But even so, the sensible thing would have been to notify the compensation event and then make an assessment of the cost that the contractor included in that quotation. And at least then the employer would have known whether there was a cost or not, because the PM would then have to have made an assessment of the quotation. They didn't do that. They simply argued that there was no cost or time effect. So we didn't even get to the quotation stage with this in this particular dispute, which seems to me to be bizarre. I think, dare I say this, they were probably badly advised by somebody in this particular instance. So just a quick reminder of what you've got in the ECC. So I just scheduled out here. So certain compensation events have to be notified by the project manager. Certain ones have to be notified by the contractor. And the one that was causing all the problems was this one, which has to be notified by the PM. So and because it's the PM's job to notify, if the PM doesn't notify, the contractor is not time barred if they then decide to notify the compensation event. So that was not the end of it. That was not the end of it. The story continued. So when it came to the quantum, there was further issues. And the further issues were that the contractor was then instructed to submit a quotation for the compensation event, because now the Court of Appeal had decided that it was a compensation event. So what we need now is a quotation. So what the housing executive did was then they instructed the contractor to provide a quotation, which the contractor duly did. Now, again, some of you may know when you provide a quotation for a compensation event, it has to cover time and money. That's really important. And another important principle is that there's this principle, what's called the dividing date. So, and this applies to time and money. So when you're assessing a quotation for a compensation event, what you do is you stop the clock at the date the instruction was given, and any work completed at that up to that point will be on an actual time and materials basis. Any work completed after the dividing date will be on a forecast basis. Now, the instruction was given to Healthy Buildings relatively soon after the work started. So the dividing date was many, many months ago. So that was the date when the instruction was given. And so what Healthy Buildings did was they said, well, applying the principles of this contract, and I would just flick to where they are in the contract. So very quickly, whoops, sorry, that was a bit quick, too quick. So the money aspects are clause 63(1) in the ECC. That's where we know about the dividing date. And when it comes to time, then it's 63(2), which tells us the same thing when it comes to assessing time. So just coming back to what they did, they made their assessment, and there was only a relatively small amount of work that was completed at the dividing date when the instruction was given. The rest of it was all after the dividing date. So the contractor put together a forecast of what they said the costs would have been, including any risk allowances, and submitted the quotation for acceptance. Now, this is where the dispute starts, because the employer said, well, I want to see all the costs you've incurred since the dividing date, because that's going to help us with our assessment. The contractor said, no, you can't have that, because it's a forecast. All you're entitled to is a forecast, not the actual cost of forecast, because that's what the contract says. So this is when the employer decided that wasn't right. They proceeded to court to get a decision on whether the contractor should provide that information or whether they shouldn't. And so the court agreed with what I've just said, that that's what the contract requires, that anything after the dividing date is on a forecast basis, anything up to the dividing date is on a time and materials basis, sort of day work basis, you could say. And they agreed with that. But then they went on to try and understand what forecast meant. So what the employer wanted was actual cost. They wanted to know how much the contractor had actually spent on changing their method of working, because I do think the employer genuinely felt perhaps that there had been no real increase in costs. So anyway, they put pressure on through the courts to get the contractor to provide that cost information. So the court considered the word forecast, and what does forecast mean? They agreed it was supposed to be a forecast, but this is where it got a bit strange, because the courts took views from other cases where forecast had been considered, and what they decided was that forecast actually meant putting together an assessment based on the best information available. So if you're producing a forecast, you're going to use the most accurate and up-to-date information you've got in order that you make a forecast. So bizarrely, the court said, well, in that case, the employer would be entitled to all the cost information so that they can assess the forecast. So the court decided and instructed the contractor to provide that cost information so that the employer could make their forecast. We don't know what happened after that, how much was paid, but effectively there hadn't been any further action on the quantum, but effectively both cases were all about the way the NEC works, the process. Not critical of the NEC in any way, it was just how the NEC operated. how it was intended to work. So that kind of brings us to the end of the session. So I suppose if you've got any questions or any points you want to raise, then please do that now. I'm happy to take questions.
Anybody have any questions for Nigel?
Yes, Robert. Just open your mic, Robert, and go for it.
Yeah, the one with the ICI and the MMT one.
Yeah.
I'm not understanding why they allowed it to rack up to 20 million or when it was easily identifiable they had an issue and they weren't going to get any money from ICI. Why didn't they just cease payment on cease working? And because they weren't going to get paid for what they were doing.
Well, the independent project manager, acting as the project manager should have done, was giving instructions as per the requirements of the employer. That person, the project manager, was then assessing, properly, as they should, the quotations received by the contractor. But what was happening was that as the total of the prices was growing, it became evident to ICI that this was going to take them outside their budget. So they then started applying pressure on the PM to find ways in which that the PM could reduce the amounts being paid. The PM was resisting this, as the PM should have done, and behaved properly. But it was really the client then proceeded to court to try and reduce the amounts paid via counterclaims and anything else they could think of. It was really, really poor behaviour in my opinion.
I just seen that the length of time it would have taken for them charges to rack up between 1.9 to 20 million must have been that ICI must have missed payments. So there must have been so many times when payments weren't made. Surely alarm bells should have been ringing.
Yeah, they were, and absolutely, and this is why it proceeded to court, that they just weren't getting paid. I guess pay less notices were issued, as they probably should have been, but effectively the PM was standing by his guns in this case, and resisting, and that's why they got rid of him. They sacked him. I think it's just really bad behaviour. I don't know what you think.
Well, I'm of the same opinion, and you'd expect there'd be some redress from the project manager at the end when it was all settled, wouldn't you?
Yeah, well, I'm sure the project manager also may not have been paid. There could have been also, that wasn't actually part of the particular issue, but yeah. But I think, as we said in the discussion, that I think it is important for project managers to decide what they think is fair and stand by that. It might be wrong, but stand by it. If that's what you think is the right answer, then that's what you have to do. Yes, Tony.
Is it fair to assume that if you're a contractor, you can request that the project manager demonstrates their impartiality in some way, i.e. if they're assessing a compensation event and you believe as a contractor that that's unfair, that you request them to demonstrate the impartiality?
I don't think you can ask them to demonstrate impartiality. I think you can ask them to demonstrate how they got to the answer, if you see what I mean. So, but I think also, just another word of warning, if you are an employer and you decide to swap the project manager for an in-house project manager, then you need to notify the contractor you're intending to do this, because the project, the contractor can take a view then, can't they? Yeah.
Okay.
Yeah. By the way,
I've got a question. Do you know on the Northern Ireland case for the 2017 one, for the dividing date?
Yeah.
Did you say that once they've issued the quote, it's got to be forecasted cost?
So the quotation then, in order to prepare a quotation, you have to go to the dividing date. The dividing date stops the clock effectively. It stops the point at which everything becomes forecast. Everything becomes actual to everything that becomes forecast. So let's say the dividing date was last week, last Thursday. That's the date we stop the clock, and everything up to last Thursday is going to be on an actual cost basis. Anything after that's going to be forecast, so that when that quotation is passed to the project manager stands at that point as well and makes the same assessment. So we're all looking at the quotation from the same viewpoint. If you see what I mean.
What if you've got actual costs for like this week though? Could you not include them within the forecast?
Well, you could, and of course the contractor will use that information to put their forecast together. But strictly speaking, once the clock has stopped at the dividing date, then everything after that will be forecast. But yes, you're right. Of course, if the contractor knows that they've spent a certain amount this week, then that will form part of their forecast. But essentially, it's a forecast. And the reason we do that in NEC world is because we have to include for any risks that have a significant chance of occurring, and that will be included as part of the forecast. And that's what Healthy Buildings did. They included risk money instead of actual cost.
Thank you.
Any more questions from anyone? No, I think we're done. Thank you. And it is just gone 9 o'clock now, so we'll leave it there. So just want to say a huge thank you to Nigel. That's been really interesting. Lots of nice comments coming through in the chat. And so thank you for sharing your vast knowledge with us, Nigel. We're having a rest from the First Thursday Club next month, so there won't be anything in May, but we'll be back in June. So keep your eye out on your email and we'll send through details for you. As always, if anyone needs a copy of the slides or a CPD certificate, either drop a quick message in the chat here now, or you can email me at any time. So thank you all for attending, and thank you, Nigel, and we'll see you all again soon. Thank you.
Thank you. Thanks very much, guys. Have a good day.
Bye.
Thanks.
Bye. Bye.